Limelight, my name is Simapolo and good evening. Now, this evening we have a new speaker in Right Honorable Anita Mongi, the woman member of parliament for Bukedea district. And Anita Mongi replaces Right Honorable Jacob Olanya, who died in Washington, United States of America, where he had been flown seeking medical attention. And being the first incident where Ugandans have had this sad moment of a speaker dying in office, the whole incident caught us unawares, and things had to be adjusted here and there to accommodate certain incidents, including the one that happened today at Kololo Independence Grounds, where members of parliament elected a new speaker after at least 9 months, when we last, of course, elected a speaker. Now, this time we can ask ourselves, how can this particular incident or any incident of such a kind be avoided? And of course, the whole issue that has been threatening to throw the country into a constitutional crisis. To understand this and much more, we will join Honorable Muwanda Nkunyinji, and he is the Honorable Member of Parliament representing Kyadondo East in the 11th Parliament. Let's now connect straight with Honorable Muwanda Nkunyinji. Honorable Nkunyinji is a lawyer, and he has that vast experience in issues to do with the legislation and, of course, to do with the justice system. Yes, let's see how we connect with him. Honorable Muwanda Nkunyinji, welcome to the Limelight, and of course, welcome back from Kololo Independence Grounds. Now we have a new Speaker of Parliament. Tell us, as a lawyer, as a legislator in the 11th Parliament, what lessons you as legislators or we Ugandans could have learned from this particular process, where we have a speaker being elected when actually the predecessor is even still in a foreign country.
Yes, thank you for this gesture. I want to salute the Parliament of Uganda and members of Parliament for going through the just concluded exercise as required by law. Speaking as a lawyer, there is no taboo or problem or dilemma in electing a speaker as we have done, following constitutional standards. Under Article 82, Sub-Article 4, and other proceeding articles of the Constitution, read together with our parliamentary rules of procedure and the Administration of Parliaments Act, it provides that at any one time, when the position of speaker falls vacant, the first sitting must only be a sitting for election of a new speaker, and must be presided over by the Chief Justice or a judge designated by the Chief Justice. So that is a constitutional provision. The office of the speaker falling vacant can be when the speaker is removed, it can be when the speaker resigns, can be like now the instant case when the speaker dies. It is not one way. So to argue from the legal angle, we don't look at one scenario. Actually, the argument that electing a new speaker when the other one is not yet, for example, buried as it is now, that is a moral argument, not a legal argument. It is a moral argument that, based on our culture and practice, it wouldn't look good. But in terms of the law, we look at a requirement of a provision. I don't think the law is wrong. It is only morally challenging in terms of the morals, that it will be preferably good to first attend to a burial, and also for Parliament it will be logically right that Parliament can stand and proceed with the Deputy Speaker, or in case the Speaker dies, among others. Those would be preferred option, and there will be no problem if they are provided for by the law. Equally, if someone has an argument to do with the burial, the laws do not have any problem with the burial. The only challenge is that the burial of a speaker is provided for under our Parliamentary Pensions Act, right together with the other laws regulating Parliament, which requires the speaker upon death to be given a state burial, a state funeral. That includes being brought before Parliament. But now, because the law provides that the Parliament cannot proceed in absence of the Speaker when the position falls vacant, it is a constitutional and legal requirement that the only way to come and officially mourn the Speaker before Parliament, in a sitting of Parliament that goes on Hansards of Parliament, is by first of all constituting Parliament again. That requires election of a Speaker, as we have done today. The other logical approach that will be given this kind of situation is that if it so could warrant, a burial could go on, and then Parliament, once a Speaker is elected, resumes and sits and remembers or hold a sitting in memory of a departed Speaker. So all those are options, but speaking from the legal line, what has transpired today is what is provided for within the law, that there has been a sitting of Parliament presided over by the Chief Justice for election of a Speaker. And indeed, Parliament has got a new Speaker and a new Deputy Speaker, and has been adjourned to next week, Tuesday. I believe as the program for burial comes in, now Parliament is ready to proceed with all officialities and technicalities as required in a burial of a person accorded a state burial. That also includes being presented before Parliament, among others. So the argument that what has transpired is a bit wanting is a moral argument. But in terms of the law, what has transpired is what is right within the law. Under Article 82 of our Constitution, we have to elect a Speaker, because it's the only way we can now have all attributes of the Speaker, as mentioned before Parliament, are being recorded and going on Hansards of Parliament. In absence of Parliament, any sitting will be informal. But now the Parliament is formal. But of course, for the future, there's nothing wrong in trying to look through the law. And first of all, with the options of, for example, allowing the Parliament to proceed with the Deputy Speaker in the case of a demise of the Speaker, or giving an appropriate time under which that can be done. But as it is now, we have had an election within the law, and this is and for us who are advocates of the rule of law, that was a must within our law. And it is specifically provided for by the Constitution, and the requirement is shall is instructive, that there can't be anything to the contrary. Otherwise, if the law can equally be amended to allow flexibility, that is logical. However, as it stands today and within our law, any challenge to do with whether it was right or wrong is a moral argument that, well, in our African society, in our society, it will be religiously and culturally challenging and a bit wanting to have such a process going on when someone has departed. But however, also be mindful that we are now talking about legislature. That is, Parliament is one of the fundamental arms of governance. Government runs on 3 arms: the executive, which is led by the president, and the judiciary, which is led by the Chief Justice, and the legislature, or as Parliament, which is headed by a Speaker, who is elected from among members of Parliament. So a demise of a singular individual should not be a basis to hold an institution of governance at ransom, that it cannot proceed under any circumstance. Being a legislature which has to do the oversight role, which also has to do the legislative role for the people of this country. So we must tag parliamentary practice and parliamentary existence to the rule of law and democratic governance, not to the moral fabric. We can only manage within the law that our rules to do with the governance and democratic process also have some resemblance and respect to human rights, to culture, to our culture, and also religion. For example, the arguments, for example, from sections of faithfuls, saying, for example, some saying some days should be respected, like Saturday, in terms of the sittings. For the Muslims, that Friday should be respected because it's a Jumat day. Among others, there are so many other arguments which also need consideration from various sections of society. But the moral argument and the cultural argument can be also co-opted as we restructure and realign the law. But again, it should not override the basic fabric of democracy and governance, that these are institutions and they are public institutions which must run, and office bearers are not targeted to the functionality of these institutions. So separating functionality of these institutions to the life and lifespan of individuals will be key in trying to redesign and redraft our legislative process.
Okay, Honorable, it's good. You have said that there is a chance to co-opt those moral arguments and other issues to possibly have an amendment in the Constitution to ensure that this particular incident doesn't happen again. But let's look at what happened. Of course, we can agree that the election of today, of course, came abruptly. Nobody expected that we would be going to another election of the Speaker and Deputy Speaker in a space of less than 1 month. I would ask you, don't you think we could have committed mistakes in this whole process? Maybe, perhaps, we bring in leaders that may be of not that good standard. Maybe we may have committed a mistake or an error here and there. Don't you think this urgency that has been employed in this whole process could have landed us into certain problems?
Democratic governance and the rule of law is not a question of time. It's a question of how the process is handled and managed, especially with due respect to the rules that govern any particular process. Now, what we have undergone is a process governed by clear provisions and our rules of procedure governing Parliament. I think it was rightly done. Secondly, the laws provide that for someone to contest as a Speaker or Deputy Speaker, principally you must be a member of Parliament. And indeed, all the contestants from the various political divisions were members of Parliament. This other initial process you saw of parties and primaries, that is not primarily envisaged within our law, and it's not quoted as part of the process. Actually, the laws governing election of a Speaker talks about a sitting of Parliament. Matters to do with the nomination, campaign, the equivalent of campaign, that is speaking for the candidate, are all done when Parliament is in session. Whatever transpired before Parliament was in session cannot be quoted as part of this process. Whereas it may have resulted into some candidates coming up and standing under such arrangement, such discussion from the party line and from various caucuses. Well, that is another issue altogether. When I'm to submit based on the rules of procedure and the law, anything to do with the election of a Speaker is a pronouncement that one, the office is vacant, whether by resignation, by death or dismissal, as it was done by the announcement, which was done by Mr. Museveni that the Speaker had died, among others. That was a declaration that someone holding a position of office in terms of Speaker has died. Now, the second requirement of the law was the clerk to Parliament to announce the sitting of Parliament where an election would be done for the office of the Speaker. That was the second part of the electoral process that led to this day. And three, anything to do with the nomination of a candidate, also speaking for the candidate, which is equivalent to the campaign, according to the laws, it is done while Parliament has sat and is in session, and it was done today. So the processes that happened before are not ordinarily envisaged within the electoral process for the office of the Speaker. They are actually secondary, call it persuasive, but not legally a requirement. Now, it cannot be used as a process as the criteria to assess the outcome. The outcome must be assessed into by first of all whether the process was preceded by following the rules of procedure, which partially and ordinarily it was actually done. Now, the other question would be the electoral process itself, as it has happened today. Indeed, there were nominations. They were speaking for the candidate. The only challenge we had was the presence of the president and issues to do with the camera, because the law requires that the exercise of election of a speaker must be free and fair and must be by secret ballot. Of course, there were arguments that maybe the cameras were intimidating the voters, among others. Well, that is another issue altogether, which can also put in contempt the electoral process. But in terms of the law, it was a sitting of Parliament chaired by the Chief Justice, and indeed there were nominations, they were voting. We had a vote, and the members who voted did not exceed those present. So I think it was an electoral process. Of course, the results were not to our expectation as the opposition, but we accept that is democracy. There must be a winner and a loser. So in terms of the candidates and the participants, being that they are members of Parliament, we would have no problem with them. Our problem would be in terms of how they use their office and after the election.
Honorable,
in days to come, our only hope
thank you so much, Honorable. Our time is fast spent. Thank you so much for your time, and thank you for sharing with us those opinions. And it looks like you largely say that the process has been fair and done according to the law. My name is Simapolo. Thank you so much, our viewers, for sticking with us.